I'm good. How are you? Pretty good. Thank you. Thank you, children. Right on the dot. Yeah. Check it off. Good morning, everyone. Welcome to the DC Court of Appeals. Before the argument starts, if you have a cell phone, if you can turn off your cell phones or mute your phones before the argument begins. Thank you. All rise. All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeal, draw there and give your attention. God sent the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Morning, everyone. Welcome to the DC Court of Appeals. We have one case on this morning's calendar. It is a special sitting. It is INTRIAGO versus United States, numbers 17 CM 578 and 19 CO 19. And we'll hear first from Mr. Lipper.
Thank you, Judge McLeese, and may it please the court. My name is Greg Lipper. I represent the appellant, ILIN INTRIAGO. I'd like to reserve 4 minutes for rebuttal. As a direct, automatic, and immediate result of his conviction for misdemeanor sex abuse, Mr. INTRIAGO was required to register for at least 10 and up to 15 years by the Maryland Code on the Maryland Sex Offender Registry. This case, and he was tried by judge, not by jury. Since he was convicted, 2 of the court's cases have compelled the conclusion that it was error to deny him a jury trial. First, in Botto, the en banc court held that certain collateral consequences can make an otherwise non-serious offense serious, and that those collateral consequences can be imposed either from the district itself or from outside the District of Columbia. Second, in Fallon, the court held that sex offender registration, and more to the point, a mandatory appearance on a public internet-based sex offender registry is a collateral consequence significant enough to make the offense serious. Under Botto and Fallon, Mr. INTRIAGO suffered precisely the type of collateral consequence that is deemed serious, and the fact that that came from outside the district is not significant under the Sixth Amendment analysis.
It seems to me, Mr. Lipper, that your use of the term outside to describe the holding in Botto is a pretty generous reading of Botto. That case dealt with Congress and not with some other state legislature.
That's true, but I think I'd say 2 things. First of all, the reasoning of Botto, I think, extends to state legislatures as well. The government made basically the same arguments in Botto that it's making here. It quoted the same language in Noctegal. The court, responded by saying, the Supreme Court in Noctegal was talking about other states' punishments that did not affect the defendant in that case. So in other words, you can't do a 50-state survey and says, well, if I lived elsewhere, here's how I would be treated.
Can I ask you, I get hung up a little bit on the use of the word outside to describe this.
Sure.
Judge Fisher did too. I mean, Congress is physically in DC.
So I mean,
it's probably not the best term.
Yeah, it's fair.
And Congress also has relatively plenary legislative authority over the District of Columbia. In fact, the statutes that govern whether you have a jury trial or not in DC, the statutory provisions were originally enacted by Congress. And so Congress's relationship to the District of Columbia does seem at least possibly conceptually different from the relationship between the District of Columbia and separate sovereigns like Maryland. So I'm interested in your response to that set of questions.
I'd say a couple of things. First of all, I'd say in theory, but not in practice, because none of us elect any member of Congress who votes in Congress. So first of all, as a practical matter, District of Columbia population has no more say, has no say in Congress as a, on a voting level. But I think more to the point, and I think this case illustrates why the government's proposed distinction between Congress and other states' legislatures collapses in practice. Sex offender registries in particular are driven almost entirely by federal law. Very few states had sex offender registries until Congress enacted the Wetterling Act. Very few states had public sex offender registries until Congress enacted the federal Megan's Law. And each time Congress has enacted federal requirements that bind states upon pain of losing federal spending.
Am I right, though, that I take that line of thinking, which would be something like a somewhat narrower possible fallback argument, but your broadest argument doesn't depend on that. Your broadest argument is if state action dictates the consequence and is sufficiently severe, there's a constitutional right to a jury trial. Now, the idea that, well, maybe if that's too broad, at least where the state action is driven by Congress, and Congress is already, we know from Badeau, kind of part of the group of actors whose consequences you add up, that would be kind of a narrower argument. But on your broader argument, I just am a little curious how far you take it. So let's say that someone who's a citizen of a foreign country comes to the United States and gets convicted, or I'm sorry, gets charged with an offense. And the consequences that are imposed by that foreign country, not a different state, but a foreign country, are quite severe. So if the person gets convicted and goes back to his or her place of citizenship, the foreign country, as a matter of law, very serious consequences would be imposed. Do you say constitutional right to a jury trial, or is your view that it's tied to domestic state action?
I guess I'd say two things. I think there is at least a stronger possible distinction because we're dealing with a foreign legal system is at least sort of more outside, I think, the core activity of American judges, number one. Number two, to the extent the consequences are unduly severe, there may well be, to the extent there's removal proceedings or something like that, that may be an issue that comes up. And third, there may be an issue of international comity or deference to foreign legal systems. So I think you could say, at least for now, I don't think the court needs to resolve that question. But even then, I would say, even then, I would say, to the extent there was a world government dictating that every country had similar consequences, I think that distinction would break down. But again, I think for purposes here, what the Supreme Court originally said in Blanton, and then what this court quoted in Fallon, was state action. It would have been very easy for the court in Badeau to say, when the government quoted that language from Nachtigal about, quote, other states, it would have been very easy for the court in Badeau to say, well, that's a state, we're talking about Congress. But that's not what Badeau said. Badeau said, we're talking here about state-imposed consequences that the defendant is subject to.
Well, Badeau said more than that, though. I mean, I take your point that some of the United States' arguments about run up against some of what was said in Fallon and Badeau about how to interpret Nachtigal. So I'm with you. I understand that line of thinking. But the court in Badeau did say Congress, as the national legislature, is presumed to reflect the nation's social and ethical judgments.
It did, yes.
And so it's the theoretical, at least one line of thinking in Badeau seemed to be about we're gonna add in not just the local legislature's determination, but also the national legislature's determination, because that's another relevant community. That's a way of looking at it, at least. And if that's the line of thinking, that does seem to not fit very well with whether you should add in to the list of possible additional consequences that might make an offense non-petty, the determination of a separate sovereign, though a domestic separate sovereign like Maryland, particularly where that determination is conflicting with what the determination is in DC, because DC obviously does not choose to impose sex offender registration with respect to this.
And I do want to follow up on that point, and I suppose it is, you could say it's a narrower variation of the argument. I think it also does illustrate the fuzziness of the distinction, but in any event, federal law requires all states and the district to require registration for misdemeanor sex abuse of an adult. The district has chosen not to comply with that requirement under SORNA, and it to date has not suffered the consequence of a loss of federal funding. But
So it's a little imprecise to say federal law requires it. Federal law conditions.
Yes, federal law conditions upon pain of loss of a gigantic amount of federal funding, that offense be included. Now, the district has not followed along, but I mean, Maryland, I don't think it's fair or accurate to say that, the Maryland people or the Maryland legislature woke up one day and said, you know what, it would be a good idea to broaden our definition. What they did was enacted a set of amendments in 2010 and 2011 to broaden, among other things, to broaden the definition of a sex offender required to register, following the lead of Congress, which made those changes in SORNA, and thus sort of expanded the federal conditions upon receiving funds. And, part of that changes in Maryland added, what is in Maryland fourth degree sex abuse, which is the crime in Maryland analogous to DC misdemeanor sex abuse. So
You're making a point that I don't think I had seen made before. Do I understand what you're saying correctly? That federal law requires every state's Sex Offender Registration Act to require registration when a person has been convicted, when the defendant was convicted of misdemeanor sexual offense against an adult?
Yes, it does. It phrases it slightly differently. So it lists a number of different crimes. And it says, as a catch-all, crimes involving, sexual contact. And then that term isn't defined in SORNA, but there are other statutes in which that term is defined to mean physical contact, including through the clothing. And so that is one of the categories of offenses that under SORNA, states are supposed to, again, upon condition of receipt of funds.
And they don't get funding if they.
Correct. Now, there is a complicated process about when the federal government determines that a state is or is not in substantial compliance. And so, I'm not sitting here saying that tomorrow the district's going to lose, someone's going to wake up, hear my argument and take away all of the district's funding. But as a formal matter, I mean, it is not a coincidence that Maryland amended its law, expanded the category of offenders registered in 2010, 2011 as part of a series of amendments designed to comply with SORNA, the federal statute that had been enacted a few years earlier.
Mr. Lepper, perhaps I nodded off, but I don't remember reading this argument in your brief. Is it there?
This precise point is not in our brief, but the broader point is in our brief and is in Fallon, which is that, and Fallon makes this point, that most states have the same or similar sex offender registration regimes because of conditions imposed by federal spending legislation, including SORNA. In fact, Fallon itself, when it was pointing to examples of, the consequences of being on a public registry, one of the cases it cited was a case from Maryland's highest court. So, I mean, even Fallon recognized that these laws are not sprouting up independently from state to state, that they're very much a creature of direction from Congress.
In a way, this strikes me as a bit of a side issue, because the question, the way I frame it, is how serious did our legislature think this offense is in creating it? And they made it a misdemeanor. And they did not provide for a jury trial for this offense. Are you aware of any case anywhere in this country in which one state has felt compelled to grant a jury trial because another state would impose because of the penalty that another state would impose on a person who was convicted?
I'm not aware of one, but I'm not aware of one really rejecting this argument either. I think it doesn't come up that often because most states do provide for.
See, this has been discussed at times by commentators and others. And if we put aside Badeau, if we think Badeau is distinguishable because it involves an enactment of Congress, which after all is our sort of big brother legislature, as it were, since we're a creation of Congress. The notion that the right to a jury trial in this jurisdiction would depend on what another state would do runs contrary to the way in which the Supreme Court has characterized the Sixth Amendment right to a jury trial. The court has said that the severity, and when that's the right at issue, the court has said that the severity is determined by, from the perspective of the legislature that adopted the statute, not from the perspective of the defendant, how harsh it feels to the defendant, and not from the perspective of some other legislature. And if we follow that line of thinking, it seems to me the answer is that Mr. Intriago is not entitled to a jury trial here. That's why I ask you whether you're aware of any state that has ever granted a jury trial because another state, because of another state's law. And I'm not aware of any such.
I will say, and I'm not hanging my hat on this particular point, I will say there is a Kansas appellate decision that interpreted Badeau in the way that I am, which is to say other jurisdictions not limited to Congress. But I think more generally, I think Judge Lichtman, I think your point is an argument against Badeau, and I understand there was an unusually well-reasoned dissent in Badeau that made this point, but I think that is
Only some people thought so.
right. More than one person thought anyway, that I think made this very point. And ultimately, Mr. Badeau, the District of Columbia Council, likewise determined that Mr. Badeau's offense was not serious and should not get a jury trial, but the court held he was entitled to a jury trial.
Mr. Lipper, Judge McLeese will control the amount of time that you have remaining, but
Understood.
We're here on our plain error
Yes.
review, and it would be helpful to me if you could explain in face of this complexity why under the plain error standard, your client was entitled to a jury trial back in 2017.
Absolutely. So a couple of, I think, basic points that I don't think are in dispute, which is that number one, on direct appeal, the plain error standard encompasses Court of Appeals decisions that have been decided even since the trial took place. And so I think everyone agrees that Badeau and Fallon are fair game here. The court also in Miller, I think made clear that, requirements 3 and 4 of the plain error test are, absent exceptional circumstances, are satisfied by the deprivation of a jury trial. And so the question then is there error and was it plain? I think Miller is actually an important case because what Miller stands for, I think, is the mere theoretical distinction that, a judge or the government can draw does not necessarily defeat a finding of plain error. So in Miller, the government argued that.
But here we have a complication that I hope you will address. This is a very subtle point. Although I'm charged in DC, I live in Maryland and the law there is different. I will have to register in Maryland, but I wouldn't have to register in DC. How's the judge to know that? Unless the lawyer for the defendant pipes up and says, hey, wait a minute.
Oh, well, so I'd say two things. First of all, I think it's actually far less subtle a point than many of the immigration related questions are that are, part of the inquiry now under Badeau. I mean, I can say from under my own practice, a defendant charged with simple assault in the district may or may not face immigration consequences, depending on whether the charged theory is threats or physical contact. And with respect to threats, you reach that conclusion from a decision of the Board of Immigration Appeals reinforced by an unpublished decision in the Third Circuit. I mean, it's literally the steps you enjoy to identify a potential jury trial issue. Here, I mean, you look up the Maryland statute, it is plain as day and automatic.
Why would a judge do that sua sponte?
Oh, well, let me say two things. First of all, I'm not sure that at the end of the day, I mean, judges may or may not do all sorts of things sua sponte. I think here, I think especially after Fallon, that if there is a sex offense, that registration is potentially an issue. And I think you wouldn't have to go digging to know exactly where Mr. Intriago lived. He lived in Maryland at the time. It was very clear from even his, pretrial paperwork. And so there was actually an inquiry to trial counsel. And, this goes to our fallback argument, which is I think trial counsel seemed mistaken he thought mistakenly that there were immigration consequences and mistakenly that there were not registration consequences. And that goes to our alternate argument about ineffective assistance of counsel.
Before you shift to that, and I know you're over time and you've asked for 4 minutes rebuttal. We'll give you your 4 minutes rebuttal.
All right.
I did want to raise another. I've asked you some questions about the theoretical functioning of the argument that you're advocating, and I'm interested a little bit in the practicalities of this too, which you haven't explored much yet. And so, one hypothetical to explore it, I guess, is what would you say about the following kind of case? Imagine that, like this case. So imagine the issue comes up on the day of trial. Defendant is charged with misdemeanor sexual abuse of an adult, and is not going to have to register in DC, and everybody understands that. And the defendant's counsel says, "Your Honor, as of today, my client lives in Maryland and would have to register." Now, in candor, I have to tell you, Your Honor, that in a week, my client plans to move to the District of Columbia. Nonetheless, I want a jury trial. Entitled to it or not?
I would say unclear only for the thought. Well, let me say, answer your question and also just raise a practical addendum to it. I would say unclear only because I think in any case, a court can make an inquiry about a sham, right? And if this is,
let's assume this is in good faith. This is it's a lawyer raising, if it would be a lawyer, I think if I were a defense attorney and this case came out the way you would like it to,
right?
I've never been a defense attorney, so I'm not sure I would feel obliged to be as candid as to say my client.
Right.
Maybe that wouldn't be good defense practice. But assuming that a lawyer did that, I don't think that'd be a sham. That would be a lawyer saying, "There's this legal claim that I seem like it might work for my client, but I am going to acknowledge a fact that is relevant, and I'm going to argue that it shouldn't change the analysis."
Right.
So
I guess the other thing here is, and I think ultimately that's sort of the gambit of I'll move to Maryland, pocket my jury trial, and then if I'm convicted, I'll flee Maryland. And even assuming it's done in that person is going to be forced to register. And so Mr. Intriago was convicted and sentenced, and he received a 14-day he served 14 days of time, convicted and sentenced on the same day and was off to jail. And immediately upon his release from jail, he was required to register. So that situation actually would not spare a person from sex offender registration.
It might or might not, depending how long the trial took, because it might be that the move would be before the conviction. So it might or might not.
I suppose in theory that there are a number of hypotheticals. I think though that, and I say this not.
I think I have your answer to this
Right.
first line of thinking. But
Well,
the second question, you can wrap back around, but just so we get it out here.
Okay.
I'm also interested, I guess, in how geographically diverse and how so if let's say a defense attorney says my client would like a jury trial, Intriago ruled as it did, assuming it ruled as you would like, and here's my representation. My client lives in the District of Columbia, but he vacations for 2 weeks in Sanibel, Florida, and in Florida, if he's going to do that, he's going to have to register. You would say jury, doesn't matter where it is in the country, doesn't matter how voluntary the exposure to that possibly geographically remote jurisdiction is, doesn't matter how long it is, if registration is required, jury trial is demanded, there's an entitlement to a jury trial. Is that or would you be narrower?
Well, I would say if you say it doesn't matter how long it is, assuming that vacationing for 2 weeks a year in Florida exposes someone to minimum of 10 years of sex offender registration, then I think that's still a real consequence that they're facing. And it's still, now I will say, and I say this not to fight the hypotheticals, but to just illustrate that. And I mean, I think underlying the reasoning of Fallon is survey defendants who are willing to serve all manner of time in jail to avoid being put on a sex offender registry. So I think the idea that someone would sort of, stick their head into the lion's cage in order to get a jury trial is unlikely, because if you stick your head in a lion's cage, you're likely to get your head bitten off. And ultimately, efforts to expose yourself to sex offender registration increase quite significantly the risk that you will be subject to sex offender registration, especially given how quickly these requirements come down. I think obviously if there's real questions, if the person's never gone to Florida before and never, then the court can inquire as to sort of whether this is bona fide or not. But I think in the garden variety case, which is we're dealing with defendants who live in the district or work in the district and live in Maryland or neighboring states, and you're dealing with states regimes that are very, very similar, comparable because of the common source of federal law, that these inquiries in practice are far more straightforward than they are under immigration law, which involves a lot more variation, a lot more complexity, and a lot less established law. And I would add that in immigration law, you still have the added step of a removal proceeding and possible defenses, whereas, I mean, I'm not exaggerating when I say Mr. Yajo's conviction made it like automatic and immediate. There was no administrative hearing in Maryland, nobody had a pass on anything. It was just over and done. The second he served his 14-day sentence, which he started on the day he was convicted, he was on that registry for a minimum of 10 years.
May I ask one further question? With regard to this question of the applicability of plain error, assuming you are correct that that there was an error here, that it was plain, and that it satisfies the third requirement of a substantial impact on fundamental rights. Could you speak to whether the fourth requirement of plain error is satisfied, the requirement that the error affect the fairness, integrity, or public reputation of the judicial proceedings? Because I'm not sure I see that, even assuming that the first three criteria are met.
So I'd say two things. First of all, I think under Miller, it's presumed that it does, and the government has not suggested otherwise. But I think even as a practical matter, in this case illustrates the stark differences between trial by a single judge and trial by a jury. There were a number of factual findings made by the judge that turned very much on what people's incentives are in the workplace with respect to asking for money, the risk of losing their job, the way they, would respond to, racial insensitivity or racial harassment. And, the trial judge very quickly said, well, it's unlikely that the complainant would have asked a, colleague for $20. It's unlikely that Mr. INTRIAGO would have threatened to report her because she insulted him racially. It's unlikely she would have done this in order to keep her job. Those are things where I think, a broader cross-section of jurors, people who have faced financial insecurity, who have worked in low-wage jobs, who have experienced, racial harassment or racial insensitivity. Those are the types of questions and credibility determinations and sort of parsing through how people would act that a sort of diverse group of people, really can provide. And so I think even if we're parsing it at an individual trial level, there were real differences, again, between the findings of fact by a single sort of professional, judge who is unlikely to have faced many of these practical, workplace issues.
I'm frankly not sure your answer, which is a good one, addresses Judge Glickman's question. I understood Judge Glickman to ask about prong 4 of plain error review. Your answer seems to me to go to the third prong, substantial impact on substantial rights.
I suppose, I mean, I didn't mean, certainly thought I was answering it. I think ultimately there's some overlap in these inquiries. I mean, I think more broadly, and as identified in Miller, deprivation of the right to a jury, the right to a jury of your peers, or denying someone entitled to that right is sort of the loss of a significant bedrock right.
It seems to me the question is more, should the District of Columbia be embarrassed? Because in the facts of this case, Mr. Intriago was not given a jury trial when he didn't ask for one.
I mean,
And when most people in the District of Columbia tried with this offense would not have a jury trial.
and I would say, I'm not sure, I mean, I would say to the extent you're putting it that way, the answer is yes. Most people would serve at most 180 days and beyond with their lives. Mr. Intriago served 14 days in jail, but, you know, for the next 10 or to 15 years, all of his, you know, kids' classmates can look this up and, you know, make fun of them and harass him and his family. And, I do think, you know, again, if you ask, I think virtually anyone, would you rather serve 182 days or 187 days in jail on the one hand, or be on a sex offender registry for 10 to 15 years? I think 100% of the people would take the extra few days. So I think
we accepted that principle in Fallon. So this case doesn't really implicate that question. Exactly.
But it does in terms of the, you know, severity of the injustice here. And again, I do want to stress that I think the government has not challenged this. And I think one reason perhaps they haven't is ultimately, you know, you have a bedrock right, the right to a jury of your peers. You have a conviction that turned on a credibility determination, which could have been made by 12 people, 12 diverse people, and instead was made by one person. And the consequence of that was not, as in the usual case, up to 180 days in jail, but rather sort of a fundamental ruining of this person's life for 10 to 15 years. So I think applying that plain error standard, this is a significant and uncommon injustice, I think, because again, most people, virtually everyone who is subject to that consequence, to that collateral consequence, does get a jury trial.
Which prong of the fourth requirement for plain error do you think it satisfies? Did it make this trial unfair? Did it destroy the integrity of the trial? Or did it damage the public reputation of judicial proceedings?
I'm honestly not sure how finely I would parse those things, but I think the concerns I identified could implicate any of those. I think, depending on who you're looking on, because ultimately, you know, the public reputation of, you know, someone typically, you know, would get a jury trial before facing such a significant consequence. But Mr. Intriago, by virtue of the happenstance that he happened to, although work in DC, happened to live across the border, did not. That his argument that these credibility determinations, which turned very significantly on workplace and racial dynamics, were not made by, you know, a jury of his peers. All of those things, I think you can say, you know, any of those, I think all of those permutations get at the same thing. And that ultimately, the reason Fallon ultimately, I think, turned and Botto before it turned predominantly on an analysis of what are the consequences to the defendant as a result of state action. And the consequences here faced by Mr. Intriago are every bit as severe as those faced by Mr. Fallon. In fact, he's potentially on the list for 5 years on the internet for 5 years longer than Mr. Fallon.
I think we have your argument.
All right.
And we'll give you your 4 minutes of rebuttal.
Thank you.
Good morning, and may it please the court, Eric Hansford for the United States. In extending the jury trial right for DC code offenses to deportation that's imposed by Congress, this court in the en banc Botto decision reasoned that Congress reflects the nation's social and ethical judgments, and that Congress alone can impose the penalty of deportation. That logic does not translate to sex offender registration that is being imposed only by the Maryland General Assembly. The Maryland General Assembly's views do not reflect the judgments of the district's citizens, and the DC Council has specifically rejected sex offender registration as a penalty for the defendant's conviction. It has concluded, to the contrary, that MSA adult is a conviction that should not get sex offender registration. At the very least, given that it was not plain error or ineffective to fail to press these arguments before the Botto en banc decision had even issued.
So let me press, I think I know your answer from what you just said. Let's assume tomorrow Mr. Intriago showed up for trial for the first time and we remove the plain error gloss. His attorney says, we need a jury trial. And we demand one because Mr. Intriago lives in Maryland and here's what's going to happen to him if he's convicted. Is he entitled by the Constitution to a jury trial?
He is not. And that is because the logic of Blanton is we are not looking at the consequences on an individual defendant. That's the wrong lens to use. Instead, we are looking through the lens of what the legislature is doing as reflected in its penalties.
Or the legislatures from Butto.
Or Congress. So Congress would be an extension, yes. But the lens we are looking through, which is consistent with what Botto says, is we are trying to decide how the relevant society views this offense. We are not looking at.
I think your opponent's argument is to say, really, the relevant community is any jurisdiction that has the authority to impose consequences on the defendant through state action as a result of the conviction. And so you should add Congress if Congress has chosen to do that by way of immigration legislation. But you should add if there are other jurisdictions that have the authority, perhaps because of where the defendant lives or whatever other reason, have the authority to impose the consequence, then you should add them too. They're part of the community, the national community. They're another subpart of the national community that has legal authority to impose consequences on the defendant in virtue of the conviction and has done so. What's wrong with that line of thinking?
Because that is not the logic of any of these cases of
Why is it-
Blanton, of not to go. So over and over in all of those cases, over and over, what they say again and again is we're looking for a legislature's judgment.
Well,
The
again,
judgment.
singular. Every time you say the singular, I get a little confused because after Botto, we know that sometimes we're looking at multiple legislatures' judgments.
Well, I mean, Botto can't overrule all those Supreme Court cases, Lewis and Noctegal and Blanton. Botto doesn't.
Well, no, and do any of
Botto
them?
fits it in.
But none of some of this turns on how to interpret language in Blanton and Noctegal, where you say what other states are doing doesn't matter. And I had thought that in Botto and in Fallon, our take on that had been, you got to read that in context. That's in a context where the state legislatures were not imposing these consequences on the defendant. And the argument was a different one, which is if you're trying to figure out whether an offense is petty, don't look to only what the jurisdiction that is imposing the consequences does that can impose consequences on the defendant at issue. Look at what other jurisdictions generally do. And one can say that the language in Blanton and Noctegal is ambiguous on that point, but I had, Botto and Fallon seem to have read that language to be limited to settings where we're talking about state legislatures who are not actually imposing consequences on this particular defendant.
So maybe I'm misremembering, but I don't think Fallon addresses this at all. Fallon didn't have to get into this because this is all about what the DC Council was doing in Fallon. In Botto is the one case where they're looking beyond the DC Council, but what Botto reasons, and the key reasoning is on 1257, so they address this argument. What they say is through the penalties mandated by public officials and elected representatives, the laws and practices of the community are taken as a gauge of its social and ethical judgments. Congress, as the national legislature, is presumed to reflect the nation's social and ethical judgments. Moreover, it is the only legislative body that can prescribe the penalty of removal for a criminal conviction. None of that logic translates to what the Maryland general.
I guess that seems less clear to me than you're saying. I am with you when you get to the point of 1257 where they start talking about the court starts talking about Congress. But the sentences before then, which your opponent relies upon, seem not so limited. And they seem, without, I mean, so there's like some general principles that the court is arguably stating in Bedeau, and then they apply it to Congress. And the question is, do those general principles apply to other legislatures that have the authority to impose consequences directly on a criminal defendant, though the offense is not being prosecuted in their jurisdiction? And what this said is, you look to objective standards, and without saying the legislature or any singular term, what is said is penalties resulting from state action, e.g. those mandated by statute or regulation. Then it says through the penalties mandated by public officials and elected representatives, generally, not like of the enacting legislation, the legislature at issue, the jurisdiction that created the offense and in which the offense is being prosecuted. And then it just is like the laws and practices of the community. Like what community? A national community, which it's just all that line of thinking seems to be it seems to be a non-frivolous argument to say the way to read Bedeau is state action is what is required. Now, here's the part of Bedeau that talks about the particular kind of state action that was at issue in Bedeau, which was about Congress. So then they talk about Congress, but there's nothing in there that's expressly like, it would be absurd to think that anything other than Congress would work. That's not done.
So it does not. It does not say that all state action is supposed to count. What I read that sentence to say is that only state action is supposed to count. And that is also what Blanton says. So in other words, if private employers are going to be firing you based on your criminal conviction, that doesn't count. That's where that language is taken from in Blanton. But when you are reading the Blanton case, Lewis, it's not just the language, it's the logic of those cases, which is that we are trying to use the objective standards, the objective penalties that are being imposed by the legislature as a gauge for whether or not.
Again, I keep getting hung up when you say the legislature.
Well, it seems to me that there is language in Bedeau which can be interpreted in different ways if applied to a situation that wasn't present before the court in Bedeau. And so we have to respect the reasoning of Bedeau, but it's not entirely clear that what Bedeau said was really addressed to the situation we have here, or that it is anything more than dicta to the extent it is viewed as addressing that situation. That doesn't necessarily tie our hands. But let me ask you about a point Mr. Lipper made. If I understood correctly, he said that Congress, when it required states to have sexual offender registration regimes, said essentially, and your regime should require registration for misdemeanors, sexual offenses against adults. That's our view as Congress. We think it's pretty serious, and we can't force states to do things they don't want to do, perhaps, but we'll cut off your funding if you don't do it. That's what I understood Mr. Lipper to be saying. Do you agree that that is what Congress said? And if it is that in a sense equivalent to, for present purposes, to Congress, to the congressional action that we deemed controlling in Bedeau?
So I think just preliminarily, I agree with the court's questions when that argument was raised, which is that it's not in the brief. So we haven't gone deep on that either.
Now that we've heard it, should we?
Sure. Well, just to say, my thinking through it on here is not the same as briefing it, but spending clause legislation like SORNA is not equivalent to an actual requirement like in deportation. It's an encouragement for the states to adopt certain legislation, but it is not the same as for example, with the immigration law, where you've got a uniform scheme that Congress is setting.
But let me press you on this, because it seems to me there may be some legs to his point. We are told that in my view, we are told that the relevant legislature, whichever that is, and Congress is apparently included in the relevant legislation, their view, that legislature's view of the severity of an offense is what determines whether there's a jury trial right under the Sixth Amendment. Now, One way they tell you how, and the main way, they tell you how severe they think the offense is by the penalty that they impose. And when Congress imposes deportation, that's pretty heavy duty. So we say, okay, and Congress is a relevant legislature. So we say, okay, well, that's enough for us to say that this is severe enough that it requires registration. Well, if Congress, they may not have imposed a penalty, but they said, we think this is severe enough to require registration. We, the Congress. And in fact, states will cut off your funds if you don't do it. Why isn't that an argument that Congress views, regardless of what the council thinks, Congress views this offense as severe enough that it should get a jury trial?
So you are, in the question, you said that penalties are a primary way or
You would
an
say
important
the only
way.
way, right?
Yeah, but I think that's what I think Blanton directly says penalties are the only way we are looking at this. Blanton says we are looking at how society views this. And then the next sentence of Blanton says, and the way we are determining how society views this is we are looking at the penalties imposed. And Blanton is rejecting an older regime, which consistent with Baldwin's rejection, Franks's rejection of that regime, where there was kind of a more nebulous, larger surveys of how is it that different states view this? How is it that the common law views this? And Blanton is saying, no, we are not going down that road anymore. How we are now addressing this issue is we are going to look at the penalties imposed. That's the only way we're going to get from petty to serious.
And the question, I guess, is a little bit what it means to impose a penalty and whether that has to be direct or whether that can be sort of effectively indirect. Because I take it as a given, but I'll ask to see if that's explicitly a given, that if Congress, assuming it had legislative authority to do so, passed a national SORA law that required registration here, that you would agree that the logic of Badeau and Fallon taken together would compel a conclusion, even if DC didn't require it, that if federal law required it, that jury trial would be required. Do you agree with that?
I'm not sure we do, but I
What would be
agree.
the reason
Badeau-
to distinguish it?
Badeau has two strands for why we're looking to Congress. One strand is we are going to look at, because Congress reflects the national legislature, and so its penalties count. The other strand is it alone can impose the penalty of deportation. And it's emphasized over and over again. So in other words, the DC Council can't make a determination of this should be a deportable offense or this shouldn't be a deportable offense.
I have your possible distinction.
Sure.
Assume for a moment, and that's a perfectly reasonable line of thinking that is an interesting question. So I take that thought. Assume for a moment, though, that it would, I don't mean to imply a view on it. Just assume for a moment that it would be, it would require a jury trial if Congress directly imposed a particular kind of consequence. I mean, another issue that is, I think, pending in front of the court is about firearms disabilities. So, again, assume, situation A, assume that there is assume that we're true, which I'm expressing no view on,
Right.
that if an offense that was otherwise petty would require a jury trial if a particularly expansive or intrusive firearm disability was directly imposed by the legislature that was in which the offense was committed, in which the case was being prosecuted. So assume that's true, and then the next question would be, okay, what if Congress imposes that? And your point would be maybe distinguishable from Badeau because Badeau might have rested on some theory of exclusivity that isn't applicable there.
Right.
So I get that, but there's another question would be, assume for a moment that exclusivity is not the key. And if, if the national legislature has the authority to and does impose a consequence as a result of conviction, that's going to dictate a jury trial right, even if the local legislature did not choose to impose that consequence. Do you think there is zero room for, or do you think it's at least unclear under our law, what would happen if instead, rather than directly imposing that consequence, Congress, you pick your term, incentivized that consequence by threatening loss of substantial federal funding for jurisdictions that declined to impose that consequence?
So I think if Congress is acting through again, not having briefed this, but thinking through it now, if Congress is acting through spending clause legislation, then it is not equivalent to a requirement. That's the whole point of spending clause legislation. And there are all these Prince issues of when it gets too coercive or Obamacare Supreme Court decision of when it gets too coercive, and there are lines so if there's permissible spending clause legislation that encourages states to adopt certain regimes, but is not requiring it, that is not the same as an actual requirement. That is not the equivalent. And I think it's important to note with this SORNA legislation that's at issue here, the vast majority of states are not in compliance with it. And the District of Columbia Council has specifically rejected sex offender registration as a consequence for this offense.
It strikes me that maybe your argument amounts to this. If Congress adopted a joint resolution saying we deplore misdemeanor sexual abuse of anyone, adult or minor, and we think sex offender registration is a good thing, that would not be a penalty?
Correct.
And you compare what I just said to what you understand the law to be.
Correct. That's exactly right. And indeed, Blanton is saying we don't take, including Congress's views, we don't just take how society views this in kind of a nebulous way. We are looking for the actual penalties that are being imposed. So yes, I agree that's kind of the equivalent of just kind of a joint resolution condemning this action generally. That is not relevant in trying to determine whether something is petty or serious. And that's also consistent with this court's case law saying that, we're not looking at the legislative history to try to figure out if the DC Council or the other legislative bodies viewed this as a serious offense. That's not the relevant question. The relevant question is what's the penalty imposed? The name escapes me, but there was a 2019 attempted stalking case with the jury trial right from this court post Botto that went through exactly that sort of reasoning. I would also say that in terms of the argument that the consequences are what we're supposed to be looking at, that's specifically rejected by both Miller and Lewis, which maybe got a bit less play in the briefing, but both of those say we are not looking from a defendant's point of view at the consequences being imposed. We are instead looking at how the legislature views this. And so the practicalities for a particular defendant are not going to be what determines whether there's a jury trial, right? If there are no further questions, we would ask this court to affirm.
Thank you, counsel.
Thank you. So I want to pick up again on the Miller case, which I believe was the case my friend was just referring to, the 2019 post-Botto case. The Miller was a plain error case, and I think it makes a couple of points that are quite important here. The first point here is that the first point that I think Miller stands for is just because the government can come up with a theoretical distinction with Botto does not mean there is no plain error. Because in Miller, the government said, well, yes, removal is a collateral consequence, but this defendant was already removable. And so this isn't the same as Botto. And this court said, nonetheless, it is still plain error, notwithstanding this potential distinction in terms of what the defendant was actually facing. That's the first point.
And that's certainly right. And the issue then becomes how plausible is the distinction? And the analysis in Miller was that the distinction really didn't fit reasonably with the logical structure of Botto, and therefore it wasn't really a plausible distinction, and therefore it didn't render unclear the application of Miller to those circumstances. And
correct.
So then it really gets us back into the question of how plausible is a distinction between congressionally imposed consequences, what was at issue in Botto, and consequences imposed by an adjacent separate sovereign. And so,
absolutely.
And Miller doesn't tell you the answer to that question at all, really.
Absolutely.
You just have to make a judgment about whether that is sufficiently plausible possible distinction to make this issue unclear, or whether instead it isn't really a sufficiently plausible distinction to make the issue unclear. Is that the right frame of reasoning, you think?
That's right. But then the next thing that Miller did was then sort of again describe the analysis as it understood it for Badeau. And it quoted language from Badeau, which in turn was citing to Blanton, saying, quote, Blanton's focus on the potential penalties that are faced by the accused individual. And elsewhere in Badeau, and again, this is calling back to Blanton and Noctegal, talking about the possible penalties, this is again from Badeau, possible penalties faced by the accused claiming the right to a jury trial without regard to the mechanics by which the penalty is imposed. Noctegal and Blanton themselves, it would have been very easy for the Supreme Court to say, we don't care about these other states because they're other states, they're categorically irrelevant. That's not what the Supreme Court said. The Supreme Court said, we don't care about them because you are not subject to their punishments here.
It's a recurring theme in oral arguments and briefing where party A says, well, it would have been so easy for the court if it meant what my opponent thought to just say that clearly, which is true. But I mean, it's equally true that if the thinking in Badeau was, this is state action, it counts. It would have been easy to say that. That's not what the court said in Badeau. It said it's state action and then said Congress is a national legislature and went on. And so if Congress, if Badeau meant what you thought it meant, it would have been easy in theory for the court to have clearly said that. It didn't, which is why we're here. And that's just a recurring theme. I mean, it's generally true that in retrospect, if the court, where people are unsure what an opinion meant, both sides could say, if it meant what my opponent meant, the court could have made that clear. So I'm not sure how far that gets you in this setting.
But then I think it goes to the sort of the practical question and the prong 4 analysis in Miller talked again, sort of re-emphasized both the importance of the Sixth Amendment right and why it would make sense under any analysis for two defendants both facing 10 or more years on a sex offender registry. One gets a jury trial and one does not because he happens to live across the border. Or put differently, only the defendants with enough resources to relocate themselves and their families from Maryland to DC before their trial are spared, can receive any protection. Ultimately, Mr. Intriago faced the same, if not more severe punishment than that faced by Mr. Fallon, suffers each and every consequence that Mr. Fallon suffered.
I mean, this gets to the distinction that's been drawn between looking at for purposes of the constitutional right at issue, between looking at the severity of the offense from the perspective of the legislature and looking at it from the perspective of the defendant. If you contrast, for example, the Sixth Amendment right to a jury with the right to effective assistance of counsel, the right to effective assistance of counsel, the severity, the consequences are looked at from the point of view of the defendant. But the Supreme Court has made it very clear that, well, as clear as anything gets these days, right? We look at the severity of the offense for purposes of deciding whether there's a Sixth Amendment right to a jury trial from the perspective of the legislature. And what they have in mind, I think, is the legislature that imposed the penalty. Now, Badeau does deviate from this in an important respect that you do have a point. Because if you look at the severity of the offense from the perspective of the legislature, then it's all or nothing. All defendants either get a jury trial or they don't. It's very odd that Badeau endorsed a regime where some defendants do get it and some defendants don't get it, even though they're charged with the same thing. Even odder, as the dissenting opinion of Judge Fisher pointed out, that citizens of the jurisdiction should be deprived the right of a jury trial, while foreigners who've come in might be entitled to it. It's certainly an oddity. And it's not clear to me we want to expand that oddity. How do you respond to that concern?
I would say two things. I would say, with respect to the quality of the dissent, I think the majority in Botto actually disagreed even with the premise that it was an oddity. They said it was hardly anomalous because the other hypothetical defendants aren't facing removal. And so I don't think it's fair to say Botto or Fallon. It's not purely what is in the brain of the legislature, of the particular legislator. It is what have the state actors done? What consequences have they imposed on this class of defendants? The potential penalties faced by the accused individual is the way that Botto put it. And so Mr. Intriago, he is.
Do you think that the Congress thought that a sex offense committed by an alien, an undocumented, a non-citizen, who could be deported, is more serious, is a more severe offense than the same offense committed by a citizen?
Do I think Congress did?
Yeah, I mean, because if we really take seriously the notion that severity is determined from the perspective of the legislature, then it seems to me to make no sense to say that, well, two people who are charged with having committed the same offense, one will get a jury trial and one won't. If the severity of the offense from the point of view of the legislature is the same.
So this is where I think that illustrates that theory is not the theory, or certainly not the complete theory animating Botto. Because if that were the theory, then Botto, as the dissent point out, would have turned out differently. I think, so if Mr. Intriago was coming in to say, look, I do not face these consequences that are objectively serious under Maryland law, but, Maryland will, make me wait in line for an extra 3 hours when I get my driver's license. And I have a condition that makes that especially torturous, right? That's a sort of argument that would be rejected, because that's very much a unilaterally from the defendant's perspective, but objectively speaking, that's not a severe punishment imposed by the state. But here, Mr. Intriago, like anyone in his shoes, anyone who is charged and convicted of this crime in DC, but who happens to live or work in Maryland, will be put on a sex offender registry. And so in that respect, it is very much a potential penalty that he is facing.
Can I ask you, I've been mulling over the somewhat new line of thinking about sort of congressional entanglement and funding, and the judgment that is reflected in what it is conditioning funding on, as reflecting national legislature's determination of seriousness, maybe not directly imposed as a penalty, but tightly tied to penalties in the sense that it's consequences, whether you call them penalties or not, but consequences for sure. It seems like I was originally thinking that was a narrower line of thinking, but in some ways, if taken to its extreme, it seems like it would be broader. And I assume you're not arguing this, but I'm just curious to make sure I understand. So let's imagine someone who lives in DC and is therefore not subject and is charged with misdemeanor sexual assault on an adult and abuse on an adult, and therefore is not going to actually face sex offender registration, at least under current perceived conditions. Now, you obviously might have had it move somewhere. It's always, who knows what will happen in the future. But if the argument was, well, fair enough, but if you look at the congressional statutes, the congressional federal SORNA statute, it requires jurisdictions to do this. DC has, on pain of loss of significant funding, DC hasn't done it. Nonetheless, Congress is a relevant legislature. It is added to the mix of judgment, legislative judgments. It's true it didn't impose a penalty, but its funding conditions show a view of severity that means that this should be jury demandable even for folks who don't directly face the penalty. I assume you're not arguing that.
No, because I think
that the penalty be faced by the person.
Because I think that argument would be foreclosed by the government's language from Noctegal, because it's sort of a sense of Congress, but not a sense of Congress that translates into an actual potential penalty being faced by the defendant. The reason I bring up and the reason Fallon also brought up the common federal origins of all these laws is to say it is no argument against considering the Maryland consequences, which are actually faced by defendants to say, well, Maryland doesn't reflect the sense of the nation in the way that Congress does, because the Maryland is following Congress's lead. And so ultimately the question remains, what is the state act, what penalties is the defendant exposed to as a result of state action? But I think the one problem with this line between other states and Congress is that in many cases, and certainly in this case, the judgment of other states is actually sort of ultimately reflecting the judgment of Congress. And it shows why ultimately, both formally and practically, the relevant consideration is, and the relevant consideration is, what penalties are imposed, or is the defendant exposed to as a result of state action?
Does it, well, I wonder, it has occurred to me there's a different way to interpret this and Botto, but let me add a preliminary question. In your view, does it matter how many states impose sex offender registration requirements on misdemeanor sexual offenses against adults? In other words, suppose Maryland is the only state. It just happens, Mr. Intriago lives in Maryland, but out of 50 states, and forget about territories in the district, only Maryland imposes those requirements on a person in the position of Mr. Intriago. Would that make a difference to your argument?
Not in the bottom line, because again, it's a penalty imposed by the state that the defendant is addicted.
See, I've been thinking that actually maybe Botto didn't go far enough. Maybe what Botto, in the following sense, maybe what Botto should have said is Congress thinks this is really a very serious offense. And, we respect Congress. They're our big brother legislature and they speak for the nation. So the offense, everybody who is charged with a misdemeanor sexual offense against an adult is entitled to a jury trial. Because the offense, the seriousness of the offense is the same, regardless of whether you're deportable or not. The issue is not, remember, the issue really is not from the perspective, the severity from the perspective of an individual defendant. It's the severity from the perspective of the legislature. Now, Congress, no, we didn't say that in Botto. Everybody's been assuming that Botto means only people who are deportable are entitled to the jury trial when they're charged with these misdemeanors. But I wonder if really the right way to think of this is Botto didn't go far enough. If you accept that Congress's, views count, I suppose.
But again, I think the premise of your question is that it posits a different sort of theory and reasoning than the one actually adopted by Botto, because I think there are two ways to kind of look at this inquiry. Sort of what was in the mind of the legislature or legislatures about how serious this offense was on the one hand, or on the other hand, what as a result of the legislature's enactments, what consequences is the defendant potentially subjected to? And Botto chose the latter. Botto, essentially, and that's why a citizen who doesn't face removal doesn't get a jury trial, even though Congress has said, we think this is a really bad thing to do, so bad that we're going to remove you if we can. But ultimately, what Botto turns on is not sort of the moral sense of the legislature or legislatures, but ultimately the sort of what that is translated into, what potential penalties. And so we don't look at individual sort of subjective circumstances of the defendant, but we do look, the focus on, this is right out of Botto, the potential penalties that are faced by the accused individual. So I don't think it's fair to say it's not at all from the accused's perspective. It is from the accused's perspective. It's just that it's not their subjective perspective. It is, objectively speaking, what penalties do they face upon conviction and how bad are those penalties? And that, I think, explains, on the premise of Botto why it didn't need to go further, and why Botto said it is hardly anomalous that a citizen doesn't get a jury trial, because ultimately the citizen, the citizen isn't facing that state action that the non-citizen is.
Thank you, counsel. I think we have
Thank you.
your argument. We thank both counsel for their briefs and arguments, and the case is submitted.
All rise. This honorable court is now adjourned.